Welcome to the Rational Egoist. I'm your host, Michael Liebowitz. Today's guest is a professor of law at George Mason University, and he's the B. Kenneth Simon Chair in Constitutional Studies at the Cato Institute. Professor Ilya Somin. Am I pronouncing that correctly?
Yes, you are.
Ilya Somin, welcome to the show.
Thank you for having me.
So I wanted to have you on today to talk about the constitutionality of federal immigration laws. But before we get to that, I assume that when it comes to constitutional interpretation, you're an originalist. Would that be correct?
I would say that I'm a presumptive originalist and that I
Okay.
think there should be a presumption in favor of following the original meaning, but there could be extreme situations where that presumption is overcome by other considerations.
So does that mean the originalist aspect means that if the text as it would have been interpreted by the people that existed at the time it was written, is that what you mean by originalist?
By and large, yes, though certainly there are some controversies over what exactly is meant by the
Sure.
people at the time.
Okay. So you believe that the federal government, according to the Constitution, has no authority to place restrictions on immigration, right?
I would say that they have no general authority,
Okay.
but there could be narrow circumstances where some other power gives them the authority to restrict particular categories of migrants. Most obviously, in a situation where the U.S. is at war with a foreign country, it might then have the power to restrict entry by citizens of that country for so long as we are at war under the power to declare war.
But not under circumstances, for instance, to protect American jobs or to keep our culture intact, the sort of
Yes,
arguments that we hear.
yes.
Okay. So why would you say, because most people just assume that the government can pass these laws. So why is it unconstitutional for the federal government to have general
So
authority over immigration?
whenever we ask questions about government power, it's worth asking, what does the Constitution actually say about the subject? If you look at the text, you would generally assume that if some major power is given to the federal government, then it would be listed somewhere in the Constitution. That seems like a reasonable assumption. And
Sure.
if you look at any of the articles of the Constitution, whether the original Constitution or any of the amendments since then, strikingly, there is nothing in the text that actually grants a power to restrict immigration. And that's not because this was some small, insignificant power, so it wouldn't have been important enough for them to list, but rather because I think most of the people in the founding era, including such people as the father of the Constitution, James Madison, they believed that, in fact, this power was not given to the federal government, unlike a long list of other powers, which are specifically listed and enumerated, including ones that are of much less significance than restricting immigration would be, such as even the power to set weights and measures, the power to create post roads. Many other relatively smaller powers are specifically listed either in Article 1 of the Constitution, which enumerates the powers of Congress, or Article 2, which deals with those of the executive.
Right. So in Article 1, Section 8, was where Congress's powers are enumerated, there's nothing in there that gives them the authority, or if I'm reading it correctly, to regulate immigration. But I think it's important to make clear this is not an argument about whether immigration laws are desirable or whether it would be efficacious for the country to keep people out. That's a totally different scenario. What we're talking about is what authority do they have? And if they don't have it, then the proper way to go about getting it would be to pass an amendment if we thought that they should have that power. Is that an accurate
Yes.
assessment of things?
Now, it is certainly the case that people have tried to infer the existence of a power to restrict immigration from other things that are listed, and we can talk about some of those arguments by inference. And it is also the case that the Supreme Court ultimately ruled in 1889 in the Chinese exclusion case, where they said, well, even though this power isn't strictly listed. We just have to assume that it's there because all sovereign governments have this authority. So we can't imagine it not being in there. I call this the it's got to be in there somewhere theory of the immigration power, though more formally legal theorists call it the inherent power theory. But if you're looking for something which specifically lists it in the way that, for instance, the power to regulate interstate commerce is listed, or the power to raise armies, or the power to declare war, or the power to institute certain kinds of taxes. It's certainly not specifically listed, and those who defend the existence of that power, they either have to infer it from something else, or they have to say, well, it's got to be there even if it's not listed.
Yeah, the reason this is such an important topic to me, and I've been debating about it for years, is because it's usually the same people that argue that we ought to be going by the original meaning of the Constitution, that we shouldn't infer powers, from the document, and judges shouldn't, basically assume that they're there, are the same people that want to pass immigration restrictions. It's usually those on the right, and they say, oh, we have to keep, the immigrants out. We have to secure our border, but at the same time argue for a strict interpretation of the Constitution. And those are two contradictory positions. And you actually stole my first question. My first question was going to be, because I have a list of some of the theories that are out there. And one of them was that it's just inherent in the sovereign power. It seems to me, though, that by that logic, you could give the government any power that you wanted to, and just say, oh, well, of course the government has the power to do this, whether it be over, welfare state programs or immigration laws, the war on drugs, whatever. We could just say, well, the government must have these powers, but then you wouldn't need a document to restrict their power, because you would just say, oh, they would just do what governments do, right?
I'm not sure I would go quite that far, but it's certainly the case that you could infer a lot of things that way. The theory is something like, well, in the 18th and early 19th century, this is one of the powers that every European government was assumed to have. So our government should have it also. And James Madison actually specifically rebutted this argument in his report of 1800, where he criticized the Alien and Sedition Acts of 1798. And he said, no, we cannot assume that the US federal government under the Constitution necessarily has whatever powers European monarchies had, because part of the whole point of setting up the Constitution as a new system of government was, in fact, to break with European precedent in various respects. It's called the American Revolution for a reason, that it set up a new system of government on new principles. And there are many powers that European governments of that era traditionally had, that, as he pointed out, the US federal government does not have. Among other things, European governments of that era traditionally had the power to regulate and restrict religions they disapproved of. They generally had the power to impose forced labor on people, which was a common practice. They could do many other things that we should not assume that the US federal government had the power to do merely because various European rulers of that era had that authority.
Right. The whole point was to make this a different type of country that wouldn't
Yes.
be like the old world. It was the new world, and we would have a different set of rules to govern us. Okay, so one of the clauses that they point out to is the naturalization, because the power over naturalization is granted. So why wouldn't that encompass immigration?
So the power to grant naturalization is a power to make someone a US citizen who isn't already, but the power to make someone a citizen is not the same thing as the power to deny them freedom of movement or freedom to work or to live in the United States. Both then and now, people recognize that you could be a non-citizen, but also live in the US or work in the US, or alternatively, you could also be an American citizen that's not in the US. In principle, both then and now, a person could be born a US citizen, but never actually enter the United States if, for instance, they were the child of Americans abroad, and they were born there, and for whatever reason never moved to the U.S. They could be a U.S. citizen all their life and not be in the U.S. So the power to grant citizenship to people who weren't citizens before is not the same thing as the power to restrict immigration. I think most people recognize that at the time of the founding, and today's sort of distinction between the two is also clear.
Right. And in the debates, in the Constitutional Convention debates, and in the sort of back and forth at the time, the argument for the naturalization power, one of them anyways, was based on the idea that people that were here from other countries could become citizens run for office and basically infiltrate the country. It'd be, as you know, if they were to be a senator or a congressman or, you know, representative. But that is a very different thing than saying they can't come to the country. To say that somebody can't be a citizen until they meet X criteria is not the same thing as saying they can't come to the country unless they meet certain criteria.
Yeah. So I think there is a difference between being a citizen, which, at least at the time for men, included the power to vote, to run for public office and the like, versus merely living in the country, working, and so forth.
So I recently read an article by a guy named Rob Natelson. Is that the way? Yeah, Rob Natelson. And he argues that the power is inherent in the power to define and punish crimes against the law of nations. He says that that gives them the power, and it was understood at the time that that would include the power to restrict immigration. I think he's wrong, but I would like for you to explain why is it that he's wrong about that.
I think I also think he's wrong in that the law of nations, which is a fancy word for international law, at the time certainly said that nations could restrict immigration if they wanted to, but that's not the same thing as saying that violating a government's immigration laws is itself an offense against the law of nation, or that international migration somehow is an offense against the law of nation. It's no different from saying something like the governments at that time had the right to impose taxes within their territory, or the right to regulate commerce within their territory. It doesn't follow that a violation of the tax laws of a country or of the commercial regulations is a violation of international law. And it similarly doesn't follow that crossing a boundary or even doing so illegally, that's a violation of international law. That was not the case then. It isn't even the case today either. So at most, this was a power that, as far as international law was concerned, governments could exercise if they wanted to, but it doesn't follow that any violations of that power, or of any violations of laws that were enacted by countries using that power, that those violations are considered violations of international law.
Okay, but to play devil's advocate, if they were granted, I understand what you're saying. It's not necessarily a violation of international law to have immigrants come into the country. But if they're granted the power, if Congress is granted the power to define and punish those laws, couldn't the define part be interpreted as the power to restrict immigration?
Only if you want to say that the defined part includes the power to define anything Congress wants as a violation of the law of nations. They could just as easily say that possessing marijuana is a violation of the law of nations. Failing to pay your taxes is a violation of the law of nations. Almost anything could be so defined. I think the reasonable way to interpret this is that this is a power to define the exact contours and penalties associated with things which actually were violations of the law of nations, but it's not an indefinite power to say anything that Congress wants to call a violation of the law of nations is going to be so called.
See, I would interpret, now obviously I'm not a legal scholar, but when I hear law of nations, I think going back to like Hugo Grotius, and it's the interactions between governments, like the laws of war. If you're going to go to war, these are the laws you have to follow, or, how sovereign states deal with each other, not how the citizens of one country.
So that's largely correct, but it also included some things in international bodies of water and the like, which involved offenses by individuals. For example, piracy was a violation of the laws of nations. And so both the US government and European governments of that era define piracy as a violation of the law of nations, even though most pirates were not agents of a government. And there might be some, in modern times, there might be some other things which are also violations of the law of nations, such as some types of human trafficking, perhaps, and the like. So it's not quite the case that it's only limited to interactions between governments, but it also is not the case that any interaction of any kind between a citizen of one country and the government of another automatically falls within the international law.
Okay, that makes sense. All right, what about Article 1, Section 9? We can't restrict migration or importations of such people as the states would allow until 1808. Now, the argument goes that when they say importation, obviously they're referring to slaves, but migrants wouldn't be referring to slaves, and therefore after 1808, Congress would have the power to restrict that. Is there any merit to that position?
Not much. First, it's worth remembering that this is not actually a grant of power at all. It's a limitation on power. It says you can't do this until 1808.
Yes.
So it doesn't actually affirmatively grant any authority, just limits authority to presumably exist elsewhere. The presence of the word migration has indeed sometimes been interpreted to suggest what that means or must win a power to restrict immigration. But in reality, what I think this is referring to is the fact that in addition to the horrible importation of slaves that obviously happened, there was also the institution, which in the 18th century was very important, of indentured servitude. That is people who, because they couldn't afford to cross the Atlantic in any other way, they would sign a contract saying something like that: in exchange for having my passage across the Atlantic paid, I would agree to work for an employer in either the British colonies or later United States for a period of usually 7 years. And you wouldn't be allowed to leave that employer during that time. And you would only be working just for room and board, plus obviously the fact that they paid for your passage. And in the 18th century, it was understood that the power to regulate foreign commerce included the power to regulate the shipment of articles of commerce. And I know this is sort of cruel and in some ways inhumane to talk about it this way, but slaves were understood to be articles of commerce, but so too were indentured servants, because the idea was once the indentured servant signed this contract, he became a kind of commodity, albeit he voluntarily became a commodity, whereas a slave obviously had no choice. So what the indentured servant did was a shipment of an article of commerce, but he was also migrating rather than simply being imported because he agreed to the status, whereas obviously a slave did not. But James Madison and others at the time correctly recognized that this clause does not imply the existence of a general power to restrict immigration. At most, it implies that maybe indentured servants and their entry could also be regulated by Congress after 1808, though as a practical matter, by 1808, there wasn't much in the way of indentured servitude anymore. The institution had gradually died out as it became a little bit cheaper to cross the Atlantic without having to become an indentured servant.
Okay. So basically, it's an exception to the Commerce Clause. What
Yes,
this is
the
doing
power
is
to
saying
regulate foreign
these are
commerce.
the two. Okay, these are the two exceptions.
The principal goal of this was to prevent Congress from regulating the slave trade until 1808. Sadly, several of the southern states essentially insisted on this exception as part of the price of agreeing to sign on to the Constitution. When 1808 did come around, Congress did in fact ban the slave trade, which is good that they did, but obviously would have been better to do it earlier. But there was not a general sense, well, now we have the power to restrict immigration too.
Okay, so I think that going back, if we look philosophically, we're a country that it was founded based on philosophy, right? And if you go back to the founding document of the country, I know it's not quotable in court, but if you go to the Declaration, for instance, and you think about the philosophy at the time, and it was, all men are created equal, we're endowed with certain rights. It seems to me that one of those natural rights that they spoke of would be the right to migration, to move from one place to another. And nothing would contradict that idea, because people did at the time, they especially at the founding of the country, they wanted people to come here, right? Yeah. So given that they wanted people to come here, given that it's a country founded on individual rights, a country founded on freedom, given that there's no power granted in the Constitution to do such a thing, and specifically they talked about wanting people to come here and not wanting to deter people, it seems to me that the onus of proof in this argument ought to be on those who want to restrict immigration and not on those who want open immigration.
Yeah, I agree. At least if you're an originalist, that's certainly where the burden of proof is, or if you support the natural rights philosophy of the Declaration of Independence. It's worth noting that in the section where the Declaration enumerates various grievances against King George III and the British government, one of them actually specifically relates to immigration, where they accused King George of, quote, endeavoring to prevent the population of these states, for that purpose obstructing the laws for naturalization of foreigners, and refusing to pass others to encourage their migrations hither. So essentially, they accused King George of illegally and unjustly restricting immigration to what were then the Britain's American colonies. I think more generally, if you look at the Declaration of Independence and the philosophy of Enlightenment liberalism generally, which I think underpins the American founding, one is it was against arbitrary restrictions based on parentage and place of birth. And of course, one such arbitrary restriction is the idea that if your parents are not American citizens, or if you were born in the wrong place, then you should not be allowed to live and work there unless they give you permission. And secondly, and strikingly, most nations in the world today, they're founded on a notion that this is a nation for a particular ethnic or religious or racial group, like the French, the Japanese, the Germans, and so forth. Strikingly, the American founding is not based on the idea, well, we're a distinct American ethnic group or linguistic group. Obviously, we're not. Most Americans at that time spoke English, and their ethnic origins were similar to those of the people of the United Kingdom or Britain. So the idea is that the nation is founded on principles of liberalism or the Enlightenment, whatever you want to call it. And one of those is a presumption against arbitrary restrictions on liberty based on things like parentage, place of birth, and other things that people cannot control. And this is an obvious tension with immigration restrictions. Now, it is certainly true the founders didn't always live up to their own principles.
Sure.
The issue of slavery is a glaring exception, but they knew that slavery was wrong, even though many of them continued to practice it because they were somewhat hypocritical or failed to live up to their own principles. And equally, that many of them, I think, also recognized that immigration restrictions were problematic for similar reasons.
So there's a lot of evidence, it seems to me, throughout history of what the founders view of this. Now, one thing that you mentioned was the Alien and Sedition Acts and what the response from Jefferson and Madison was. So what exactly were the Alien and Sedition Acts? I mean, specifically, it'd be the Alien Acts that we're talking about in this context. So what was that?
Yeah, so the Sedition Acts were a bunch of restrictions on freedom of speech. I think that people well remember and condemn today. The Alien Acts, which were just as controversial at the time, there were two of them. One was the Alien Enemies Act, which enabled the president to expel the citizens of nations that the U.S. was at war with. That act actually was not that controversial. It was generally assumed that Congress had the power to enact that. On the other hand, there was the somewhat misleadingly named, from our perspective, Alien Friends Act, which essentially gave the president broad power to expel any foreign citizen that he thought might be a threat. And this led to a huge outcry on the part of Jefferson, Madison, and what we today call the Democratic Republican Party, though at that time they just called themselves the Republican Party, not to be confused with the later Republican Party of the 1850s. They said this was unjust and wrong, but also that it was unconstitutional. And after a prolonged fight over this, the resistance was so great that President Adams never actually managed to actually deport anybody under the Alien Friends Act, at least so far as is known. And when Thomas Jefferson won the presidency in 1800, he also chose not to use this act and allowed it to expire and be terminated. And while certainly the Federalists, the supporters of this act, did defend it, and it was motivated by fear and prejudice against certain types of immigrants, especially French immigrants, that may be familiar to us from later periods when people have thought that immigrants are a threat to American values or are a menace to national security and the like. But it's worth noting that at the time, the critics of the act, including Jefferson and Madison and many others, they ultimately prevailed. And for a long time thereafter, there was very little in the way of any federal immigration restrictions on into the 1870s.
So when was the first, after the Alien and Sedition Act, when was the first exclusionary immigration law?
The first significant ones were in the 1870s with the Page Act of 1875 that imposed some restrictions on Chinese migration. Much more significant was the Chinese Exclusion Act of 1882, which banned the vast bulk of Chinese immigration to the United States and was very obviously motivated by racist hostility to the Chinese. And by racist, I do not mean in some very broad expansionary definition of what's racist, where like somebody might have committed a microaggression somewhere. I mean blatant bigotry in the most, even in the narrowest possible sense of the word, people openly saying that the Chinese are an invading horde, that they can't be assimilated, that Chinese, the white workers couldn't be expected to compete with Chinese workers, because the Chinese were more hardworking and more willing to endure bad conditions and the like. And this is what led the Supreme Court in the 1889 Chinese exclusion case to uphold the immigration restrictions on the theory that it's an inherent power that doesn't need to be enumerated anywhere. And even in the opinion written for the court by Justice Stephen Field, even there, the racism is very evident. He specifically says the difference of race, that's his words, not mine, is one of the reasons why the Chinese had to be excluded, and that they were, and then otherwise they could be like an invading horde that would, overwhelm America and so forth. So ironically, the group that many today, including even many conservatives, regard as a kind of model minority, in the 19th century, they were particularly hated and feared by nativists, and inspired the first major federal immigration restrictions in a long time, and also the ones that ultimately led the Supreme Court to rule that such restrictions are constitutional.
So basically, it's 86 years from the founding of the country till we had the first major restrictive immigration laws, right?
It depends on what you call the founding of the country. If the founding
I'm saying under the
17
Constitution. Once we be judging by the Constitution.
So obviously the Alien Acts of 1798 were important legislation, or they turn out not to be effective. If you exclude that, then you would have to go to either 1875 or 1882, which is, I think if I'm doing the math right, in one case would be 88 years, and if you wait to 1882, it would be 95 years.
Okay, well, I was going 1789 to 1875 was I was doing.
Okay, so that would be 86 years.
Yeah.
If you want to go from the moment when the Constitution was considered ratified, that it might be 1789. Obviously, it was drafted in 1787, but
okay,
we're talking approximately 85 to 90 years, however you count it. During that period, there was certainly controversy over how much power the federal government had in this area. But for a long time, the dominant view was that it had very little or none. And that view was eroded over time, in large part because of fear of immigration by nativists, particularly Asian immigration, the fear of which gradually displaced previous concerns about French immigrants, Catholic immigrants, and Irish immigrants as the major focus of nativist hostility.
And that's exactly what I was gonna mention, was that this wasn't the first time there was a nativist reaction against immigrants, but it was the first time they actually went ahead and passed laws. So I mean, it's not a strong assumption, but I think it is there that had they believed there was a constitutional power to restrict immigration, they certainly had the motivation to do so much earlier than 1875.
Yes, although I would note, obviously in 1798, there was the Alien Act, which was in part driven by nativist fears, in this case directed at various European immigrants, particularly French ones. Later, while there were nativist movements in the 1830s, 40s, and 50s, their political power was not as great as that of the anti-Chinese nativists in the 1860s and 70s, because while there were a lot of people who hated and feared, particularly Catholic immigrants, the hatred and fear was not as widespread as the hostility towards the Chinese. And I think the racial difference did make a difference there.
And the Alien and Sedition Acts, I think it's very important to really drive home the point that they inspired such a reaction from the author of the Declaration of Independence and the named father of the Constitution, namely Jefferson and Madison. They ultimately wrote the Virginia and Kentucky resolutions saying that the states had the right to nullify laws they thought were unconstitutional. So, I mean, it's not like they just passed this Alien and Sedition Act and it was accepted by the founders of the country. Maybe some of them, sure, but two pretty big voices at the beginning of the country were adamantly opposed to this and thought that it was very much unconstitutional.
Yes, they and the entire Democratic Republican Party. It's also worth noting that when Federalists, who for a time in the 1780s were the majority party, favored this and passed this, one is that included a lot of people who simply came to argue that the federal government had extraordinarily broad power almost across the board, which was a problematic vision itself, but some Federalists held it. And second, of course, there was a nativist movement, which with the rise of the French Revolution, it was feared that if too many French people or too many people influenced by the French arrived in the United States, then we might have like some sort of French Revolution like movement in the US. This in retrospect seems like paranoid. It was unlikely to ever come to fruition, but these concerns did exist and they did motivate the Alien Act of 1798. So while today it seems silly to think, well, the French people are somehow incompatible with Americans or cannot be good Americans or whatnot, at the time there was that fear because of what happened in France with the Revolution and the Reign of Terror, and later the rise of Napoleon.
Right. So some of these elites in America were probably concerned their heads would end up either on pikes or under the blade of a guillotine.
Or at least they found it in their interest to spread this fear. In addition, there were some who worried, I think, that just as today some Republicans say, well, our concern is the immigrants will come in and they'll vote for the Democrats. So at that time, obviously, there were many Federalists who worried that if immigrants came in, became voters, that they might vote for the Democratic Republicans and enable Jefferson to win the presidency, as opposed to John Adams.
All right, there's just a couple more points I want to cover. The other day, I was having a debate on Facebook with a conservative here in Connecticut, where I'm from, who was a former candidate for public office. And his argument was that the Mexicans coming over the border is tantamount to an invasion. And then he goes to basically the power that you said that the government has, where if we're at war, they can pass laws restricting immigrants. To me, that's such a stretch of the concept of what an invasion is as to render it meaningless. But I have to ask you, would you consider that the Mexicans coming over the border in the amounts that they are, is that an invasion in any meaningful sense of the term?
No, it is not. And in fact, this is another argument that Madison addressed in his report of 1800 about the Alien Act, because some people did indeed say, well, the federal government should be able to use its war powers to exclude people even from countries that the U.S. is not at war with. And he said, well, an invasion is an operation of war. So an army crossing the border, or perhaps even a terrorist group crossing the border, that's an invasion. But a person migrating simply for the purpose of getting a better life or a better job or escaping oppression, that's clearly not an invasion. And I would say the same thing, by the way, is true of illegal drug smuggling or other smuggling across the border. That may be a crime. It may even be something we would want to prevent. I don't think so. I oppose the war on drugs, but I can understand the opposite point of view. But it's pretty obvious that drug dealing, even if it's a bad thing, is not the same kind of bad thing as an invasion. And the way to deal with it, if it should be dealt with at all, is to restrict the drug smuggling, but not by restricting immigration generally. The Congress does have the power under the Constitution to regulate commerce with foreign nations. So while I would oppose doing this, it would be a bad thing. It could restrict, say, the importation of fentanyl or any drug, just like it can restrict, other products that might be imported from abroad. But that's different from restricting migration. And it's different from dealing with an invasion as well.
Okay, the final thing I want to cover is there's this argument that the immigrants are coming here and they're getting welfare benefits. We're paying for them to go to school. They're getting health care benefits, basically that they become beneficiaries of the welfare state. So now I want you to take your constitutional hat and kind of spin it and look at this from a different perspective. Would it be, or is it constitutional for the federal government to grant benefits, such as the ones I named, to immigrants coming over the border? In other words, if they come over, they cross the border, is it constitutional to pay for them to go to school, pay for their health care, and whatever the other benefits there are to being in a welfare state?
So I would say it's constitutional to whatever extent it's constitutional to for federal spending to do this for native-born citizens as well. And I think the constitutionality of a lot of federal spending is suspect under the original meaning of the spending clause of the Constitution. That could be a whole new podcast if you wanted it to be. Under current precedent, the federal government can spend money on virtually anything that Congress says is beneficial in some way. And that would apply to spending on behalf of immigrants as well. But I would add that when you look at the fiscal burden of immigrants compared to the amount of money they pay in, the vast majority actually do pay in more than they take out. We already have various restrictions on immigrant eligibility for welfare. If you wanted to, you could make them tougher, but we should not use welfare eligibility, or in this case, even just potential welfare eligibility, as an excuse to restrict people's liberty and to destroy enormous amounts of economic value. If we were going to do that, then we could just as easily say that we should be able to restrict natives from having additional children. Statistically speaking, if a poor American has a child, there's at least a decent chance that person might end up on welfare benefits as they grow up. Or if a single mother has children with a single mother, it's more likely to be an issue than if it's an intact family. Similarly, we could say, I live in Virginia, which is much wealthier than neighboring West Virginia. So maybe we should be able to prevent West Virginians from moving here because they're poorer on average than Virginians. So they might overburden Virginia's welfare state or its schools. So I think the ultimate answer to this is that if your concern is about welfare benefits, then restrict that, but also that migration creates enormous new wealth that in the overwhelming majority of cases more than offsets any additional expenditures it generates. Economists estimate that if we had free migration throughout the world, we would double world GDP. The world would be twice as productive as it currently is. In addition, immigrants to the US and to other Western nations disproportionately contribute to entrepreneurship, scientific innovation, medical innovation, and many other things that have enormous benefits for natives as well as the immigrants themselves. To take just one recent example, both of the first two major COVID vaccines that were approved by the US government, by European authorities, Moderna and Pfizer, were developed in large part either by immigrants from poor nations or the children of such immigrants. If they or their parents had been barred, we would likely have taken much longer to get the vaccine. Millions more people would have died. And the same thing is true of a great many other scientific, technical, economic, and medical innovations. So if we had more restrictive immigration policy than we already do, we would be much worse off. By contrast, if we drop the barriers, if even only a small fraction of immigrants make these kinds of major innovations, still that by itself is enough to offset any economic cost that it imposes. And when you add in the benefits of just ordinary labor by immigrants, both white collar, blue collar, educated, lesser educated, that's even more of an additional benefit that even further offsets possible costs.
See, my response, and it's based on just almost exactly what you just said, is when somebody says to me, well, I don't want immigrants coming over here because they're going to be given these welfare benefits. And my response always is, well, I think that welfare benefits, the welfare state, is just as unconstitutional as immigration restrictions. They're not, the Congress is not granted the power to enact a welfare state in the enumerated powers. So why would I argue in a case where I think the government has overstepped in one area and use it as an excuse to let them overstep in another area, where the better argument would be to descale or further limit their power rather than to increase it? That's the way that it seems common sense to me.
I largely agree, though I would note two things. One is welfare by state governments might be constitutional in many instances, at least under the federal constitution. You can argue about whether it's permissible under various state constitutions. In addition, obviously, it's not easy to enact radical reform of constitutional doctrine and constitutional restrictions in multiple areas at once. That said, even with the current structure of the welfare state, it is in fact the case that migration adds much more to the public coffers than it would take away. And if you wanted to, you could simply further limit welfare benefits for immigrants rather than trying to constrain the immigration itself. And given what an enormous injustice it is to use force to keep people in oppressive situation in places like Cuba, Venezuela, Putin's Russia, and so forth, it seems like there would have to be a truly enormous welfare burden before you could even begin to make any kind of plausible argument that that burden justifies the harm of immigration restrictions, especially when you have the obvious alternative of just limiting the welfare payments themselves.
All right, Professor Somin, did I forget anything? Anything else we should know about this subject?
So I would note there's a few other theories that people have advanced to try to infer immigration restrictions from powers in the Constitution. Probably the best known one is inferring it from the power to regulate foreign commerce. But that essentially involves equating commerce with migration or just movement. And by the same theory, if we equate Congress's power to regulate interstate commerce with the power to restrict movement, then Congress have the power to prevent Americans from moving from one state to another. And this relies on a kind of very broad definition of the commerce power that most originalists, not all, but most, would reject in other contexts. People also can try to infer it from a combination of the necessary and proper clause with other things. They could say, well, we want to regulate interstate and foreign commerce, and we admit that by itself, restricting immigration is not a regulation of commerce, but maybe it might be necessary and proper to restricting commerce, because if immigration can affect commerce. In brief, my response to that is that even if this is necessary in the broad sense that anything can be necessary if it's useful or convenient, as the Supreme Court famously said in the McCulloch case in 1819, still it would not be proper, because as Chief Justice John Marshall said in that very case, the necessary and proper clause, while it might allow power that's ancillary to something else, it does not allow the creation of a great and independent power. Something that is itself a major additional power cannot be added merely because it might at the margin help implement some other powers. And what's a great and independent power and what is just ancillary, that might be difficult to figure out in some cases. But in the case of a broad-based power to regulate immigration and restrict it, I think it's pretty obvious that it's a great and independent power. It's not just ancillary, or as I like to put it, you can use the necessary and proper clause to pin a tail on a dog, but you can't use it to pin a whole new dog on a tail. And this claiming this power seems much more into like, let's create a whole new dog category, as opposed to merely attach a tail to an existing dog.
Okay, Professor Somin. So where can people find you?
So they can just Google me, and you can find my website. In addition, I'm a regular contributor to the Volokh Conspiracy blog, VOLOKH, which is at the Reason website. And for those who want to know more about some of my writings, immigration, I have a whole book called Free to Move, Voting, Migration, and Political Freedom, which makes the case for expanding the right of people to vote with their feet, both through international migration and also through increasing freedom of movement within countries, which is a related issue, but distinct in some ways. Perhaps that could be the subject of a future podcast. Thank you so much.
Thank you so much. Well, for now, this is Michael Liebowitz signing off for the Rational Egoist. Remember, like, share, comment, subscribe. See you next time.